and then you'll need to turn it off.
Good morning, everyone. The quorum being present, Subcommittee on Higher Education and Workforce will come to order. I welcome everyone to today's committee hearing. We are in a different location and we are a little tighter in here today than we normally would be, and ask everybody's indulgence as the renovation work goes on in the committee room. We'll all be friendlier and kinder to each other today, and be closer to each other. I'd like to thank our witnesses for joining us to discuss an issue that affects far too many students: campus sexual assault. Earlier this week, as millions of students stepped foot on a college or university campus, members of Congress returned from their districts to continue their work strengthening America's higher education system. As we all know, that effort often requires difficult but necessary conversations about tough issues, which is why we're here today. Every college student should be able to learn in an environment that's safe and free from fear and intimidation. Yet for some students, that is not the case. According to one study, approximately 1 in 5 women in college has been sexually assaulted. Several universities, including Rutgers, Michigan, and MIT, report similar findings, and a number of recent high-profile cases further highlight the scope and seriousness of this important issue. As a former community college president, mother, grandmother, I know I'm not alone when I say that all of us have a responsibility to protect students from sexual assault on campus. As one university president exclaimed, "The issue of sexual assault keeps me awake at night. I feel personally responsible for the safety and well-being of all students." Another said, "I see the issue of sexual violence and sexual assault on colleges and universities as a matter of national importance." Students, parents, educators, administrators, and policymakers across the country share the same sentiment and have joined a national conversation about these heinous crimes and how we can better protect students. At the college and university level, efforts to prevent and respond to sexual assault are underway. For instance, some colleges and universities now require students to participate in seminars to help them understand what sexual assault is and how to prevent and report it. At the University of North Carolina, Chapel Hill, for example, these seminars reinforce a safe campus culture and explain university policies and procedures for responding to reports of sexual violence. Institutions are also improving how they support victims of sexual assault, providing resources and counseling services to help students recover from such a terrible event, complete their education, and continue with their lives. Just as important, administrators are working to put in place a fair resolution process that respects the rights of the victim and the accused. At the national level, the federal government has been working with colleges and universities to prevent and respond to sexual assault for decades. More recently, members of Congress have introduced legislative proposals intended to improve protections for college students. Additionally, the administration has established new policies institutions must follow. Colleges and universities have rightly raised concerns about the administration's one-size-fits-all regulatory approach. While well-intended, the administration has further complicated a maze of legal requirements, added to the confusion facing students, administrators, and faculty, and made it harder for institutions to guarantee student safety. As Dr. Rue will explain during her testimony, the patchwork of federal and state policies has impeded the efforts of administrators and educators to prevent and respond effectively to sexual assault on their campus. As Congress works to strengthen higher education, It must ensure tough, responsible policies are in place to fight these crimes and support the victims. I'm pleased we have a panel of witnesses to represent all sides of this difficult yet important discussion. Your observations and recommendations are vital to our efforts to help colleges and universities provide students the safe learning environment they deserve. With that, I now recognize the ranking member, Congressman Hinojosa, for his opening remarks.
Thank you, Chairwoman Fox. I join you in welcoming our distinguished panel of witnesses. The subject of this hearing is extremely sensitive. As ranking member of this subcommittee, I believe that we must raise the level of awareness in our communities and throughout our nation about the seriousness of campus sexual assault and its impact on our victims, both women and men, and their families. These impacts are far-reaching and include poor academic performance, stress, depression, and abuse of alcohol and drugs. In addition to supporting the victim, we must also be sensitive to the rights of the accused. Institutions of higher education must have processes that ensure fairness in handling the allegations of campus sexual assaults, and that campus investigations are consistent with our nation's long-standing principles of due process. Whatever system is put in place, we must ensure that victims are not afraid to come forward. Unfortunately, many victims are reluctant to report sexual assaults because of shame, or fear of retaliation, or worries about lack of proof, uncertainty that what happened constitutes assault, or possibly because they lack of information on where or how to report the assault, and fear of being treated poorly by the criminal justice system. As a nation, we have made progress towards better understanding and addressing this serious challenge of campus sexual assault. For example, through the development of the White House Task Force to Protect Students from Sexual Assaults, the Department of Justice's Office of Violence Against Women developed a multi-year initiative to provide support to programs to prevent campus sexual assault and their recent online resource center for changing our campus culture. In the year 2007, the U.S. Department of Justice also funded a groundbreaking study on campus sexual assault. The findings of that study were staggering. Let me give you some examples. Amongst women in college, nearly 20% will be victims of attempted or actual sexual assault, as will about 6% of undergraduate men. Most victims are violated in their first or second year at college. The majority, 75 to 80%, knew their attackers, often a friend, a classmate, acquaintance, or someone they dated. The study also confirmed that the risk of campus sexual assault for undergraduate women increases greatly with the consumption of alcohol and or drugs. It's clear our concerted efforts are needed to deal with these serious issues. In addition to these federal efforts, I am proud to report that my own home state of Texas is responding to calls of action. Starting this year, colleges and universities are required to inform students of campus sexual assault policies during freshman orientation. Schools are also required to review and update those policies every 2 years. Students returning to class at the University of Texas campuses this fall will also be participating in the nation's most comprehensive study on sexual assaults ever conducted in higher education. The Cultivating Learning and Safe Environments case study will be led by researchers at UT Austin School of Social Work and will include online questionnaires for students, surveys and focus groups of faculty, staff and campus law enforcement, and a 4-year cohort study of entering freshmen to identify the psychological and economic impact of sexual violence. The UT system is spending $1.75 million on this study. So I applaud UT's effort to address campus sexual assault and urge other colleges and universities throughout our country to join in the commitment to end sexual violence on their campuses. In closing, let us renew our efforts to support victims of campus sexual assault. We can't wait for yet another high-profile incident to occur before we address this issue. I look forward to hearing what recommendations our panel of witnesses may have to reduce sexual assault on our college campuses. And I thank you, and with that, Madam Chair, I yield back.
Thank you, Mr. Hinojosa. Pursuant to Committee Rule 7C, all members will be permitted to submit written statements to be included in the permanent hearing record. And without objection, the hearing record will remain open for 14 days to allow such statements and other extraneous material referenced during the hearing to be submitted for the official hearing record. It's now my pleasure to introduce our distinguished witnesses. Ms. Dana Scaduto is the General Counsel at Dickinson College in Carlisle, Pennsylvania. Previously, she was in private practice in Harrisburg, Pennsylvania, where she chaired her firm's education law practice and represented several Pennsylvania private colleges, including Dickinson. Ms. Scaduto is an active member of the National Association of College and University Attorneys and a member of the Legal Services Review Panel of the National Association of Independent Colleges and Universities. Dr. Penny Rue is Vice President for Campus Life at Wake Forest University in Winston-Salem, North Carolina. Dr. Rue is responsible for the well-being and safety of Wake Forest University students and their education outside the classroom, and is nationally known for her creative leadership in strengthening campus communities. Ms. Lisa Motz is Vice President for Government Relations for the American Association of University Women, AAUW, here in Washington, D.C. Ms. Motz previously spent 16 months serving concurrently as the interim director of the AAUW Legal Defense Fund. She's done similar work for the Now Legal Defense and Education Fund and the Older Women's League. Mr. Joseph Cohn is Legislative and Policy Director at the Foundation for Individual Rights in Education, FIRE, in Philadelphia, Pennsylvania. He's a former staff attorney for the United States Court of Appeals for the Third Circuit and a law clerk in the Philadelphia Court of Common Pleas. Immediately prior to joining FIRE, Mr. Cohn served as the interim legal director for ACLU affiliates in Nevada and Utah. I now ask our witnesses to stand and raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Let the record reflect the witnesses answered in the affirmative. You may take your seat. Before I recognize you to provide your testimony, let me briefly explain our lighting system. You have 5 minutes to present your testimony. When you begin, the light in front of you will turn green. When 1 minute is left, the light will turn yellow. When your time has expired, the light will turn red. At that point, I will ask that you wrap up your remarks as best as you are able. Members will each have 5 minutes to ask questions. Now, I want to recognize Ms. Scaduto for her comments. Thank you.
Thank you, Chairwoman Fox, and good morning, Ranking Member Hinojosa and Chairman Klein. Thank you for the opportunity to be here today. As a higher education senior administrator with a long history of involvement in the issue of sexual misconduct on our nation's campuses, I am here today because we share the committee's commitment to educating our nation's students in safe and supportive environments. American colleges and universities are happy to work in partnership with the government and others on finding solutions that will help bring about cultural change and put an end to this most serious problem. As we move forward, I want to take a few minutes to share with you some of the challenges higher education is facing in our efforts and to propose some ways in which our government and this subcommittee can further help us achieve greater success in preventing and responding to sexual violence. As I make my comments this morning, I will use the term victim out of expediency and because it's referenced in the Campus SAVE Act, but without any personal preference as to terminology. First, please recognize that the reports of sexual violence we receive on our campuses are not straightforward or easy to resolve. The sexual violence claims we see most frequently do not involve force or attacks by strangers, but happen between individuals who are acquainted, where one or both are intoxicated, and where the primary issue is whether consent to a sexual act was given. We are left to resolve word-on-word conflicts between two people whose memories may be impaired and where there are no witnesses. Add to this the fact that reports may not be made for days, weeks, or months following an event, and I can hope you see the complexity of resolving such issues in a manner that the parties believe to be fair. And while speaking of fairness, colleges and universities are committed to providing fair treatment to all of our students, including not only victims of sexual violence, but also to those accused of sexual violence. The changes over the last 4 years have resulted in complexities and challenges in maintaining the necessary balance. For example, on a small campus, removing an accused student from a class in order to keep the student away from an alleged victim before any determination of responsibility can be made may result in the accused student being forced out of a class where there are no other sections or being forced out of a class shortly before graduation. We are also often trying to navigate the complexities of VAWA, Clery, and Title IX laws, regulations, and guidance, as well as state laws, simultaneously and without the confidence that we can do so to the satisfaction of all. Employees' duties to report under various standards differ. What and how we are supposed to advise victims of their options for moving forward when they report a sexual assault are just two examples of those complexities. Additionally, the current laws and guidance do not appear to recognize the college disciplinary proceedings are not equipped to replace law enforcement or judicial functions. The members of our campus communities who are expected to meet and discharge the new standards established for resolving sexual violence claims are faculty, staff, and historically students, not judges nor lawyers. To support colleges and universities' efforts to improve culture around this serious issue, and to help us in our efforts to hold violators accountable through processes that are fair, equitable, and impartial, I recommend the following 4 points for your consideration. First, pause in considering legislation that adds additional requirements to those already complex network of federal and state laws, regulations, and OCR guidance until there has been an opportunity to evaluate whether the efforts to date are working. As a reminder, the VAWA regulations only went into effect July 1st of this year. Second, consider creating a safe harbor for higher education that does not relieve us from accountability for failures to comply, but which provides us with certain presumptions of good faith when reviewing our conduct. For example, when we are applying fact-based tests established by various laws, such as in deciding whether to investigate or not over a victim's objection, if we miss the mark but are found to have acted in good faith in our efforts, provide us with protection from penalties or administrative action. Third, if new requirements are considered at some point in the future, OCR should follow notice and comment requirements of the Administrative Procedures Act. The Title IX guidance put into place since 2001 was done without notice or comment from parties outside the agency, depriving colleges and universities, victims and survivors, and other interested parties of the opportunity to provide input that may have been helpful in improving clarity and alignment with existing laws and regulations. I'll leave my 4th point for your reading. Thank you for listening and considering my perspective as a higher education administrator.
Dr. Rue, you're recognized for 5 minutes.
Thank you, Chairwoman Fox, Ranking Member Hinojosa, and honorable committee members for the opportunity to testify about this critically important issue. The higher education community takes the problem of campus sexual assault very seriously, and we are working diligently to prevent sexual assault and to manage systems fair to all students. These are not new issues for us. It's been a priority for decades because of our genuine care for the health, safety, and well-being of our students. Currently, we must address sexual violence compliance responsibilities under a swirl of regulations. This one-size-fits-all can create resource challenges that impede our effort to prevent and respond to sexual assault. Added to these challenges now are state legislatures that are enacting statutes, creating a patchwork of conflicting regulations. Prevention and education efforts are critical to reducing incidents of sexual violence. Many campuses employ online modules, allow new students to participate in prevention programming at orientation and beyond. Online training programs educate faculty and staff to whom students might report about where to turn. According to the CDC, bystander intervention training and social norms training are promising practices, but have not yet been validated through rigorous design. So more grant support is needed to conduct evaluation research in this growing field. At Wake Forest, we use Prepare peer educators to deliver highly interactive situational programs to put incoming students' attitudes to the test and really get them to think. A highly engaging peer theater program reinforces those messages and is followed by an online curriculum that uses scenarios highly relevant to students. This program, Haven, will also give us benchmark attitudes that we can use to assess the effectiveness of our programs over time. After students have time to navigate the social scene, they'll participate in a program in their residence halls on bystander intervention training using the step-up model. Campus climate surveys are another growing practice. These are used to assess students' perception of and experience with sexual violence. And these surveys are designed to provide an institution-specific picture that in turn enables leaders to coordinate with the campus community to strengthen prevention efforts. One standardized survey imposed on all institutions would likely not accommodate the wide array of campus environments that range from four-year residential like my own to community colleges and even primarily online universities. Each institution should have the autonomy to develop the best survey given benchmarks to hit. Although prevention strategies are in place, sexual violence will still occur on our campuses. Student affairs administrators are committed to being fair and balanced to all of our students engaged in the conduct process. Critical to this process is the widely established practice of confidentiality for the victim and the accused, one of the primary reasons that a student will choose an on-campus practice over reporting to the police. One of our most important points in trauma-informed work is to allow the survivor the right to choose the path to follow in the wake of an incident. Some may want to report to the campus, some may want to report to the police, or both. Some may only want support. The institution really needs to respect that choice, to take the decision out of the victim's hand by mandating that a report of sexual violence to campus automatically is turned over to the police will create a chilling effect on the willingness of victims to come forward, exactly the opposite of what we want to happen. The confidentiality of our conduct processes guaranteed under FERPA creates uncertainty about their fairness. We know that, most recently towards the respondent. But it's important to reiterate that campus processes are carefully structured to be fair and equitable to all parties. In the recent Washington Post Kaiser Family Foundation poll, 84% of current and recent college students said they are very or somewhat confident in the school administration's ability to address complaints. We are not a court of law. Ours is an educational process intended to arrive at a fair and equitable outcome for all parties. At the core of this distinction is our standard of scrutiny, preponderance of the evidence. I think I speak for most colleges and universities in saying that we do not need more regulation, we need more consultation. Guidance from the Department of Education, coming without notice, often does not help us navigate these waters. I strongly believe it is important to provide opportunities for public comment and discussion where the full complexity of the issues can be explored from those who know them firsthand. In closing, I must express deep concern about the narrative from the media that colleges and universities care more about their institution's reputation than the rights and experiences of our students. Nothing could be further from the truth. Instead, those of us who handle incidents of sexual violence are professionals who share an overwhelming commitment to strike the delicate balance in today's legislative environment to preserve the educational rights of students, to manage fair and equitable conduct and systems, and above all, to prevent sexual violence. Thank you, Chairwoman.
Thank you very much, Dr. Rue. Ms. Mott, you're recognized for 5 minutes.
Good morning. On behalf of the more than 170,000 members, is that on? There we go. Good morning. On behalf of the more than 170,000 members, over 1,000 branches, and almost 900 college and university partners of the American Association of University Women, I thank you for inviting us to testify today. My remarks are informed by my 12 years with AUW, as well as my tenure as the Executive Director of Turning Point, a domestic violence program recognized for excellence by the Ohio Supreme Court, and also at Wittenberg University, where I was a hall director and ran a women's center that responded to incidents of sexual assault. I can personally attest to the fact that this is not a new problem. When campus environments are hostile because of sexual harassment and violence, students can't learn. It's that simple and that devastating. Schools have an important and necessary role to play in addressing this epidemic. Why? Because student rights to an education free of sex discrimination are on the line. AUW has long identified the need to end sexual harassment and violence on campuses. Our own research revealed that nearly 2/3 of college students experience sexual harassment. Just this year, a national poll found 1 in 5 women said they'd been sexually assaulted in college. This issue impacts both men and women and students from all walks of life at all types of schools. Title IX and the Clery Act provide the very tools schools need to improve campus climates for everyone. Passed in 1972, Title IX is a gender-neutral law that prohibits sex discrimination in federally funded education programs. The law requires schools to take steps to eliminate sexual harassment and violence, prevent their recurrence, and address their impacts on individual students and the entire campus. This includes evaluating current practices, publishing anti-discrimination policies, and implementing grievance procedures providing for a prompt and equitable resolution of complaints. Schools must also provide accommodations to students, such as adjusting housing arrangements and class schedules and providing academic support, actions that schools are uniquely situated to provide. All schools should have a Title IX coordinator to oversee these activities, as well as monitor patterns and address systemic problems. It's important to note that these requirements are not new, but date back to the law's first regulations back in 1975. Since then, over the course of Republican and Democratic administrations, the Department of Education has continued to provide technical assistance and guidance that promotes compliance with the law. Schools also follow a consumer protection law known as the Clery Act. It requires colleges and universities that participate in federal financial aid programs to disclose crime statistics and security information. Originally passed in 1990, Congress updated the Clery Act in 2013 as part of a bipartisan reauthorization of the Violence Against Women Act. These updates require schools to report additional crime statistics on domestic violence, dating violence, and stalking, and provide ongoing sexual assault prevention and bystander intervention training campus-wide. This public report of a school's safety efforts is valuable to students and parents and provides insight to schools working to improve campus safety. Title IX and the Clery Act are longstanding complementary laws that work together to ensure that students and schools have a clear course of action when sexual violence occurs. Appropriately, schools are not in the business of imposing criminal punishments. Those decisions are best left to authorities in charge of criminal investigation and prosecution, if a survivor chooses to pursue that course. The school's civil rights proceedings and any criminal investigation represent parallel, yet equally necessary paths. Laws and legal precedents spell out clear requirements for schools to be prompt, fair, and impartial in all disciplinary proceedings, and Title IX echoes these due process requirements. Similarly, the Clery Act requires that school processes be prompt, fair, and impartial, and that both parties receive timely notice regarding the outcomes of proceedings. There are next steps that Congress can take to help assist schools and students in their efforts to end sexual harassment and violence. We know that the time immediately following an incident is especially critical for survivors. They need access to a safe space, medical care and counseling, and information about their rights and where they can seek additional support. Schools should also ensure an advisor is available to connect survivors to all of these resources. The AUW-supported Survivor Outreach and Support Campus Act, or the SOS Campus Act, would ensure schools take these critical steps. In addition, climate surveys can help schools better to understand the dynamics behind reported and unreported incidents of sexual violence. Schools need information in order to effectively combat this epidemic. When done well, climate surveys provide transparency that is crucial for student safety and a useful tool to help schools fine-tune their response. The AUW-supported HALT Campus Sexual Violence Act would also require surveys at all schools. Finally, we urge Congress to provide additional resources for the Department of Education to support Title IX coordinators and other stakeholders on relevant laws and best practices. There are schools that are working diligently to respond to incidents of sexual violence, and technical assistance can help them make real change. Further, with more attention to sexual violence, we've also seen an uptick in complaints, and an unprecedented number of schools are under investigation for Title IX compliance. The Office for Civil Rights needs additional funding to provide ongoing technical assistance for schools, as well as to hold bad actors accountable. We all believe, I think, that a single incident of sexual violence is one too many. When it interferes with students' education, it adds insult to injury. But we have the tools to make real change, and AUW looks forward to working with you as you reauthorize the Higher Education Act and consider this important topic. Thank you.
Thank you. Mr. Cohn, you're recognized for 5 minutes.
Chairwoman Fox, Ranking Member Hinojosa, honorable members of the subcommittee and members of the committee at large, thank you for the introduction. I'm the Legislative and Policy Director at the Foundation for Individual Rights in Education, or FIRE. We're a nonpartisan nonprofit organization dedicated to defending student and faculty civil liberties on America's college campuses. I thank you for the opportunity to discuss this critical issue. One of the core constitutional rights that FIRE defends is due process. Universities are both morally and legally obligated to respond to known instances of sexual assault in a manner reasonably calculated to prevent its recurrence. And for more than 50 years, courts repeatedly have held that the Constitution requires public institutions to provide meaningful due process protections to accused students. FIRE believes that these twin obligations need not be in tension. Access to higher education is critical. The stakes are extremely high for everybody in campus disciplinary proceedings, and it's essential that no student's education is curtailed unjustly. While efforts to address campus sexual assault have focused on eliminating bias against complainants, far too little attention has been placed on preventing bias against the accused, and even more insufficient attention has been placed on addressing what I call the competency gap, the difference between what college administrators are equipped to do and what the Department of Education's Office for Civil Rights is demanding of them. Campuses are ill-suited to adjudicate allegations of sexual assault. While college and universities have a role to play in tackling the issue, we must make sure that we're assigning them responsibilities they're capable of performing well. Having defended campus due process for 15 years, FIRE is convinced that colleges are simply unequipped to serve as investigators and fact-finders in these challenging issues. Rape is a crime. It should be treated as such. Using amateur systems is insulting to victims and disastrous to fundamental fairness. Unsurprisingly, injustice for both victims and accused is commonplace. Sound public policy requires adjudicating these cases in courts after professional investigations. Only courts have the power to take violent predators off the streets. After all, a student who has been expelled but not jailed is free to commit rape again. Complicating matters further, in the April 4, 2011 Dear Colleague letter, which OCR did not subject to public notice and comment as required under the Administrative Procedure Act, the agency mandated that institutions adjudicate sexual assault cases using the low preponderance of the evidence standard. OCR, while well-intentioned, has done more harm than good in this arena. Since issuing the 2011 DCL, OCR has conducted over 130 Title IX investigations, several of which have resulted in settlement agreements. To the best of FIRE's knowledge, only one such investigation is looking into whether the disciplinary process is biased against the accused. The resulting perception of top-down federal bias against the accused is inescapable. I would like to briefly address 3 bills currently pending before Congress: the Campus Accountability and Safety Act, CASA, the Safe Campus Act, and the Fair Campus Act. There are aspects of each that FIRE supports, and there are provisions in each that give FIRE pause. On the positive side, all three bills aim to increase the involvement of law enforcement. If our goal is to implement a serious response to a serious problem, involving professionals in the criminal justice system is necessary. FIRE has multiple concerns about CASA, chief among them the fact that the bill provides no meaningful due process protections for the accused. None. Conversely, the Safe Campus Act and Fair Campus Act both include important procedural safeguards that will benefit accused students and complainants alike. What's more, both the Safe Campus Act and the Fair Campus Act would repeal OCR's preponderance of the evidence mandate, provide the complainant and respondent crucial rights to active assistance of counsel, and require institutions to turn over inculpatory and exculpatory evidence to both sides. To encourage more complainants to report allegations to the proper authorities, the Safe Campus Act prohibits institutions from taking action on complaints unless they choose to report the allegation to law enforcement. FIRE agrees that punitive measures should be waived if a complainant does not report the accusation to law enforcement for investigation. However, we strongly urge Congress to amend the language so that non-punitive measures and accommodations may still be made available regardless of the student's decision to report. While colleges have proven incapable of competently determining the truth or falsity of felony accusations, they are well equipped to secure counseling for alleged victims, provide academic and housing accommodations, secure necessary medical attention, and provide general guidance for students as they navigate the criminal justice system. Institutions should perform these functions regardless of the complainant's decision to report the incident. The bills should be amended to encourage them to do so. I provide a more detailed analysis of the bills in my written testimony to the committee. To sum up, there's no simple solution to the problem of sexual assault on campus, but lowering the bar of finding guilt and eliminating criminal due process protections. By doing that, we're creating a system that is impossible for colleges to administer fairly. Congress can help reverse this trend by taking all student interests into account. To accomplish that, Congress should include the best aspects of each pending bill in a comprehensive, balanced measure. Thank you again for the opportunity to address you, and I look forward to answering your questions.
Thank you very much. I would now like to recognize Chairman of the committee, Chairman Klein, for 5 minutes.
Thank you, Madam Chair, and thanks for holding the hearing. Thanks to all the witnesses for being here, real experts and excellent testimony. I picked up a theme, if I can use that term, when I was listening to both Ms. Scaduto and Dr. Rue about complexity. Somebody, I think it was Dr. Rue, used the word swirl of regulations and a patchwork of regulations, and Ms. Scaduto, in her 4 recommendations, the one that's written and wasn't oral, says harmonize standards, obligations, expectations under Title IX, VAWA, and Clery. It does seem to me that it is confusing because you have different statutes with different requirements. And I have great confidence that everybody in this room, sitting up here, sitting there, or sitting in the gallery, so to speak, wants to find a way to eliminate sexual assaults on campus. And should it occur, to make sure that we are holding perpetrators accountable and we are providing support and protection for victims. But it does seem to be complex. So I'll just go to you, Ms. Scaduto, in part because I lived in the beautiful town of Carlisle for a while. It's a beautiful part of the country and of the state, and my son graduated from Carlisle High School, and so I've got this tie. I've just got to go to Carlisle, and it is Carlisle, not anyway. It's a long story. Are you concerned that the emphasis that's being placed, the focus that's being placed on complying with these different federal laws, regulations, and guidance is detracting from your ability to do what's in the best interest of your students?
I apologize. Yes, we are. I think it's a concern shared not only on Dickinson's campus in Carlisle, but on campuses around the country. If we were able to harmonize, and we understand that the promulgation of legislation and regulations is done with the best of intentions in protecting our students, and it's a goal we support. But when we are spending our time trying to harmonize our compliance with the various statutes, it takes away from where I think we as educators excel, and that is in educating. And that's on the side of prevention and training that Dr. Rue spoke so eloquently about. When we have different reporting requirements, for example, under Clery and under the OCR guidance, we have the same group of employees who are interacting with the same students, but we are getting different standards for who must report and what they must report when they learn of an incident of sexual misconduct. And when that type of analysis detracts from getting a report made and responding to a student in need, it's problematic. There are ways to improve harmonization, such as the notice and comment period that could be used by OCR when it enacts new guidance, because even there's distinct differences between that and the VAWA regulations, for the Clery regulations, for example. So yes, the disharmony does prevent complications and take us off the real important work we need to do around this issue.
Thank you very much. I yield back.
Thank you, Mr. Chairman. I now recognize the ranking member, Mr. Scott.
Thank you, Madam Chairman and Ranking Member Hinojosa, for calling this hearing on preventing and responding to sexual assault on college campuses. This issue of campus safety is foremost in the minds of American families as they send their children away to college. Congress in 2009 declared September the National Campus Safety Awareness Month to help bring awareness to incidents of campus rape, mass shootings, and other forms of violence at educational institutions. 25 years ago, Congress passed the Clery Act to require institutions of higher learning to report campus crime statistics and to publish campus safety and security policies. We know the issue of campus sexual assault is complex. Nevertheless, Title IX and the Clery Act require that once the school knows or reasonably should know of a possible sexual violence, it must take immediate and appropriate action to investigate or otherwise determine what occurred. Unfortunately, campus sexual assault is usually addressed only after there's an alleged incident. We have to have meaningful procedures to hold accountable those who commit sexual assaults, but we also must do more to try to prevent them from occurring in the first place. One strategy is to educate young people about healthy and safe relationships before entering college. The Teach Safe Relationships Acts of 2015, introduced by Senator Tim Kaine of my home state of Virginia, would require that health education in public secondary schools include learning not just of biology, but also safe relationship behavior aimed at preventing sexual assault, domestic violence, and dating violence. Currently, federal law does not require health and sex education classes to include information regarding these relationships, which can prevent sexual assault. There's also a study published in the June 2015 New England Journal of Medicine that found that college women who participated in an intensive program showing students how to recognize and resist sexual aggression reduced their chance of being raped by nearly 50% and attempted rape by 62%. Now, we know that funding is also an issue, and funding is needed to implement educational programs and robust enforcement of all civil rights laws on campus. However, the Department of Education's funding has decreased or been flatlined over the years, and the agency's staffing level is the lowest it's been in 34 years, despite having a record of nearly 10,000 civil rights complaints. We can also do more to train campus public safety personnel and support evidence-based research to strengthen college safety and security, and have a clearinghouse for dissemination of relevant campus public safety information. As an example, the National Center for Campus Public Safety in January 2015 conducted its first pilot program offered in a course in Richmond, Virginia, to develop a trauma-informed sexual assault investigation and adjudication training for campus officials, including Title IX coordinators, advocates, legal counsel, and others. Let me ask just a question to all of the witnesses. Some have alluded to some of the things we can do. Can the witnesses talk about, I know we're going to talk about what to do after the fact, but what kind of strategies can we do before the fact to actually reduce the incidence of campus sexual assault?
That's an excellent question, Mr. Scott. Thank you so much for asking it. You know, working on relationships and students' understanding of safe relationships is key. And doing that before they get to college is also important. AEW's research shows that sexual harassment and bullying is prevalent in K through 12 schools, starting really, quite frankly, with preschool. So having conversations about safe relationships, having good curriculum about how to talk about those issues, and also encouraging students to look at themselves as someone who can help, you know, to look at the bystander intervention kinds of models have been really successful. The CDC studies have shown that when you really do relationship education and an emphasis on safe and healthy relationships, you do start to erode campus sexual assault. So you do need to start young. It needs to be consistent. It needs to be ongoing. And it's something that we need to get behind.
Are you familiar with Senator Kane's bill?
I am familiar with Senator Kane's
Can you
bill.
make a comment about it?
It is a bill that AEW supports. I think it's smart to look at this kind of curriculum across the country. And right now, since we know we have this epidemic of campus sexual assault, starting young is great. Doing it in high school is fine, but I also would submit you probably need to start in elementary school.
Let me just add briefly that the research is inconclusive because rarely do we have the opportunity to do random assignment of subject to group, which is where you can get really rigorous testing. So more support for research in this area would really be useful. We have what we know and what CDC calls promising practices, but we don't actually have proven effectiveness.
Thank you, Madam Chair.
Thank you very much, Mr. Scott. Dr. Rue, you mentioned the importance of prevention and education efforts on the campus in reducing incidents of sexual assault. Do you have written evaluations that you can provide us on the results of those efforts? And could you give us just a thumbnail of the greatest, what have had the greatest impact on the campus safety climate from what you have experienced?
Yes, ma'am. Thank you for the question. The two most promising practices are bystander intervention training and social norms training. In bystander intervention training, people learn the steps it takes to disrupt or interrupt what looks like it's going to be problematic behavior. The truth is peers are often able to do this, but they need the courage to essentially change the code, if you will, of what is agreed upon as appropriate social behavior. And this has been effective. Again, we haven't had studies that have shown random assignment of subject to group, so we call it a promising practice. The other practice is the social norms practice. And what social norms does is look at the gap between what people think and what people think other people think. And it really contributes to things such as rape myth. And so when you can ask through research, does a woman drinking too much suggest that she wants to have sex? You can actually measure that, and you'll find that people think other people think that, but they don't think that themselves. And so you can go back to your campus with that gap and combat those norms that are actually creating a hostile environment.
Thank you very much. Mr. Cohn, in your testimony, you make the important point that rape is a crime and should be treated as such. How could using what you call amateur systems on campus lead to injustice for both victims and accused students?
Thank you for the question, Chairwoman Fox. The primary way that the way the status quo works harms both the accused students and the complainants is that we get unreliable findings because the people adjudicating cases don't have the right tools to do it. The same people who would be fine on juries you have deans of physics departments, English professors, and sophomores trying to figure out if a rape occurred, and they're doing it without forensic evidence, they're doing it without the subpoena power, without the ability to put witnesses under oath, they're doing it without rules of evidence to make sure that relevant information is included and the irrelevant is excluded. The idea that they're going to get it right consistently with all of those limitations is a fantasy. So the primary thing that we can do is make sure that we ask people to play a role that they're competent to fulfill, one that takes advantage of the skills and what they bring to the table, and work together. And that's what I mean when I say that amateurism affects injustices.
Ms. Caduto, you mentioned that you were a negotiator in the rulemaking process for implementation for VAWA. Could you tell us a little bit more about that experience and how you believe the opportunity for stakeholders to contribute to the development of the regulations resulted in clearer and more transparent expectations for schools, especially in contrast to sub-regulatory guidance?
Happy to do so, Chairwoman Fox. Through the negotiated rulemaking, there was a group of, I believe, 14, 28 with our alternates who were very much part of the process. And we represented divergent points of views. Every view, however, folk being equally committed to dealing with the issue of sexual violence. We had higher education administrators like Dr. Rue at the table. We had counsel like me. We had security officers from higher ed. We had survivors and victims of rape, male and female, both represented. We had advocacy groups at the table. And we did very hard work. We came together over a 3-month period, and we looked at proposed language proffered by the Department of Education, and we had the opportunity to talk about whether we should drill down in a particular area and impose a single standard on a particular issue, and talk about, as Dr. Rue mentioned earlier, the fact that we need language which is fluid because colleges and universities are so different across this country. Large, small, public, private, online, commuter, all those different issues. And it was very difficult work, but I am confident that the product we ended up with at the end of that process was a better reflection of the wider community in rules and regulations that work on college campuses than without it.
Thank you very much. Mr. Hinojosa, I recognize you for 5 minutes.
Thank you. My first question is to Ms. Lisa Matz. You state in your statement that you read to us that current law requires schools to respond to campus sexual assault because a student's civil rights are on the line. You also said that a school civil rights investigation and any law enforcement criminal investigation represent parallel and equally necessary paths. Can you please explain the parallel tracks of Title IX enforcement interact as compared with criminal investigations, and why is it so important for the victim to be able to decide whether he or she wants to pursue a criminal investigation as opposed to campus disciplinary process?
Well, I think, thank you very much for the question. I think there is great confusion between what a criminal process looks like and what the civil rights process on a college campus is supposed to look like. College campuses are not supposed to be, nor would we expect them to be, enforcing criminal law. What they are doing is looking at civil rights. Has Title IX been violated? Has a woman, in this case, has her education been impacted, and therefore she can't obviously take advantage of her civil right to a sex discrimination-free education. So it's really, in that sense, they're parallel tracks, but they're very different. Schools can't send people to jail. You know, schools really look at enforcing student code of conduct. And, you know, before when we were talking about the notion of kind of amateur courts, I do take exception to that in many respects on behalf of schools, because they have been dealing with their and enforcing their student code of conducts for decades, and some issues for hundreds of years. So the reality is they know how to do that. Where there is confusion, I think, is that when it comes to campus sexual assault, schools are supposed to be dealing with the civil rights impact, not just on that individual student, but how it impacts the campus as a whole. And that's different than the criminal proceedings that we've talked about.
Thank you. Ms. Dana Scaduto, you said that colleges and universities are very concerned that despite their best efforts to follow applicable laws and guidance, achieving full compliance is not possible. And you also said creating safe harbors for colleges are not held liable under Title IX if they can show good faith efforts to meet the requirements of conflicting provisions. Can you help me understand how creating such a safe haven would reduce and help prevent instances of campus sexual assault?
Certainly, Mr. Hinojosa, it's my privilege to do so. Let's take the example. There are a couple of examples I can give you. If you take the OCR guidance, in it, we are supposed to advise a victim of her rights to report. Cleary uses the language that we have to advise the victim of her right not to report. Is there an intended difference between those? And when you put those, you take that and you put it up against a state law where if you take Cleary and you have to advise an individual of her right not to report, but there's a state law that mandates reporting of felonies by the institution, have we created a conflict between in executing on a plan that everyone wants the same outcome, but we have this swirl of differences and we're not quite sure how to comply with all of them? And in our best efforts to do so, if we err by reporting under the state law, when we have Cleary telling us we have to report, advise a woman of a right or a victim of a right not to report, provide us with protection and support that if in our best efforts to comply, we miss the mark, that we won't be held accountable for penalties or agency action. That's just one example.
Thank you. Mr. Khan, time is running out, and as I heard your presentation, brought back memories of what is approximately 20 years of service on this committee. Congresswoman Patsy Mink from Hawaii led a group of members of Congress to focus on Title IX, and there was a mindset throughout the country, especially from some certain states, that wanted that Title IX removed or weakened so that it wouldn't be a problem for them. Their mindset, the women were not supposed to have the same opportunities in sports. Now that we're dealing with this, you talk about allowing schools to set a higher burden of proof in these proceedings could make it more difficult to punish offenders. How does that contribute to making campuses safer?
I think, thank you, Congressman Hinojosa, for the question. I think reliability in outcomes makes campuses safer. And when you reduce the amount of certainty that fact finders need to hold without providing them the tools to reach the fact finding in the first place, you're not really making campuses safer. At the end of the day, don't forget, someone who's been expelled from a campus is not removed from society. They're still free to walk the streets. The campus isn't actually safer either, even with the expulsion. The truth of the matter is that schools need to not be indifferent to claims, need to make sure that they can provide the kind of services necessary to make sure that complainants can get an education the next day. And that isn't tied necessarily to being a fact finder.
Well, I want to go on record that I disagree with you because the list of universities throughout the country with violations that are under investigation right now has doubled, tripled, and quadrupled. So I think that we really in Congress need to address this.
The
And
ranking
be
member's
very
time
strong.
has expired.
I yield back.
Dr. Rowe, you're recognized.
Thank you, and thank you for the panel. This is an incredibly complicated, difficult situation. I think probably I'm the only one sitting on the dais, except perhaps Dr. Heck, who's examined women for sexual assault and has testified in court. Is my lifelong job as an obstetrician gynecologist. It is an incredibly difficult, complicated issue you all are dealing with. And Ms. Scuduto, you brought out a couple of points that hit me, requirements we have from the state. If I examine a woman in the emergency room, I break the state law if I don't report that. If this is a student, and they are in conflict. And I think it puts a great pressure, on you to know if you're doing the right thing. And I know that, and I'm going to ask Mr. Cohen in a minute about this. We certainly want to protect the rights of each one, but I can tell you I've dealt with patients over decades who've dealt with the consequences of sexual assault and how you deal with it. And I mean, it changes, it's life-changing. I mean forever life-changing. So how you deal with this is incredibly important. And I think the start you all made is that early on is education is absolutely the key to prevention. And I know, Dr. Rue, you mentioned a couple of things that really intrigued me about how you prevent that, and the results and the incidents lowered greatly. I don't know whether the incidence is greater now or just reporting is greater. I have a feeling it's just reporting is greater. I think the crime has been there all along. I think it just has been grossly underreported. So a couple of things that I'd like to know is, and I'll start, Mr. Cohen, with you, is it you're absolutely right to gather this information. I've done it meticulously before. Is very difficult to do to protect the rights of everybody involved. And I know, Ms. Matz, you mentioned we're dealing with a civil rights issue and a criminal issue. When does a school, when do you determine to turn this over to the police as a criminal, because it is a criminal act?
Well, I think that's really one of the key questions in this debate is what's the appropriate role of law enforcement here, and I'm glad you zoned in on it. At the end of the day, mandatory reporting doesn't require a complainant to cooperate with an investigation. It does, however, require that the law enforcement is aware of it so they can at least reach out and offer the services that they provide. One thing that we know, and it's a fact, is that you have only 72 hours to get a rape kit done. You have only 48 hours to get blood collected that can show whether someone was drugged against their will or perhaps if they were so intoxicated they couldn't possibly have consented. Once that time frame is elapsed, the window is gone to have that physical evidence help a claim. FIRE primarily believes that everyone will be helped by getting the right professionals plugged in as quickly as possible. Well, that's the way to build trust with law enforcement, is to make sure that they get the information as fast as possible when they can take the best and strongest actions on behalf of victims. It will also help the falsely accused to have information recorded quickly too. It will help everyone.
We've seen over time where with new DNA evidence and new evidentiary things we've had that where people have been falsely accused, and obviously you won't do process for everybody. Dr. Rood, to you, at Wake Forest University, what resources do you have for a student, either male or female, after this has occurred? Because I can tell you, as a physician, it's absolutely critical.
Thank you for your question, Representative Rowe. I agree with you that it is a life-changing event. I have sat with many, many students in that process, both men and women, quite honestly, and it's devastating. We do have 24/7 on-call confidential advisors that are available to go wherever the student is, if the student is in the emergency room or if the student has gone to student health. We have 24/7 student health, and we have 24/7 student EMTs on campus, and so we've got a nice safety net right there. The most critical link is our confidential advisor. This is the person that reaches out and establishes trust. If the first questions someone is asked by their friends are about their own behavior, they are likely to completely shut down. And so if we can get that person as fast as possible to our confidential advisor, who is trauma-informed in her counseling techniques and who can create that bond, and then accompany her or him throughout whatever processes, whether it be sitting through a police investigation, whether it be going to the housing department to make room changes or to the academic advisor. And that bond is the most important bond, and it's the most important role on campuses today.
My time's expired, but one other thing that I want you all to think about is how can we streamline this so that you're not checking boxes but taking care of students? That's where the resources need to be, and I see it all the time where all this conflab of things you have to do takes away from the real reason, which is taking care of the student and the patient. I yield back.
I appreciate your commitment.
Thank you, Dr. Rowe. Dr. Adams, I'd like to recognize you for 5 minutes.
Thank you very much, Chairman Fox, Ranking Member Hinojosa, for holding this important meeting. My thanks also to the witnesses for your testimony, and special shout out to Dr. Rowe from Wake Forest, which is partially in my district. Campus sexual assault is a very serious issue. It affects entirely too many of our students, and to be clear, even one student is too many. And so while I believe prevention through education is the best way to combat this growing problem, I appreciate your speaking to that, we must still deal with the incidents that occur. Unfortunately, that's nearly impossible to do with all the differing ways in which institutions of higher education and law enforcement agencies handle sexual assault, and it's becoming more complicated with efforts to weaken Title IX. Although North Carolina does not have a significant number of incidents currently open, The case opened at the University of North Carolina, Chapel Hill is particularly disturbing, and I'm disappointed that there's a case that's opened in my city of Greensboro at the University of, at Guilford College. I spent 40 years as a faculty member on the campus of Bennett College, a small women's college, primarily African-American women in Greensboro, and I had ongoing concerns then, and I still do. And there are many things that I could talk about surrounding sexual assault, but I want to hone in just for a moment on the effects of women of color. According to the Centers for Disease Control, approximately 34% of multiracial women, 27% of Alaskan Native American Indian women, and 22% of black women, and 14.6% of Hispanic women are survivors of sexual violence. Ms. Scaduto and Dr. Rue, both Dickinson College and Wake Forest University are liberal arts institutions with pretty good resources, I think. Can each of you speak to your campus initiatives that address the need for cultural specific prevention education for your minority students who might be dealing with the weight of other issues like racial discrimination and economic disparities?
Yes, thank you, Representative Adams. I appreciate your question. We do take our responsibilities to all students very seriously. We know one size doesn't fit all. With our African American students, we have a peer mentoring program that creates a very tight-knit bond with well-resourced upper-class students. And we have an increasing number of first-generation students, students whose parents didn't attend college. And we have the First in the Forest program that really helps those students navigate as well. We do try to utilize the best research to understand differential impact and also to get within the peer culture, because that's where these things occur. So the use of peer educators is our most important tool.
Thank you.
All I can say is the programs at Dickinson are similar. We have specialized training for African American men in healthy choices and healthy habits called Mandatory. We do many of the same things that Dr. Rue is doing. There's no question but that we can do more in cultural specific impact. But right now we're putting in place, the issue is so prevalent that right now the issue is getting all of our students trained. It's using things like Green Dot and healthy relationships and sexuality training on our campuses for all students. And I do imagine that as time passes, we will become more proficient at looking at specific communities and how they're impacted.
Thank you both. Ms. Myers, within the same vein, do you have any recommendations for the best way to ensure historically black colleges and universities who have less resources, less staff, are able to provide comprehensive prevention and response?
Well, number one, I would always encourage colleges and universities to not reinvent the wheel. There are local community services, often rape crisis hotlines, domestic violence shelters that can help with prevention programs and potentially being these confidential advisors, which is a great best practice. The other thing I would say, though, specific to women of color, is that we need to be really sensitive, especially about mandatory reporting. We know that there are issues in terms of gender bias in policing and racial bias in policing, and for women of color to mandate that they report to law enforcement is a great way to ensure that they don't report to anybody, that they don't get any help, that they don't get any support. So we need to be culturally competent about that and sensitive, and I think that it's one of the reasons, quite frankly, AUW has sent a letter to the Department of Justice asking them to create new guidance in gender bias in policing to deal with some of the different things that women of color are facing.
Thank you very much. I'm out of time. Madam Chair, thanks very much.
Thank you, Dr. Adams. Mr. Guthrie, you're recognized for 5 minutes.
Thank you all for being here. I appreciate it. It's important for us to move forward on this as we go higher ed reform. I'm in the situation, I had a daughter just graduate from college, but I have a son in college, and before I came here was planning our college tour for my senior in high school, my little girl, and so when we leave camp, drop them off those days that crush us all, and we leave them on campus and drive away, we want to make sure that we're doing everything we can here, and you're doing everything you can to make sure they're in a safe place. And so this information is going to be good for us. And you're looking like harmonizing requirements. I've learned, I was in state senate and now here, that when there's a requirement added or things done, it's because something happened. And so we're reacting to something that happened and trying to prevent it moving forward. And sometimes you get different bills that happen at different times, and so you get different requirements. And it should be an opportunity for us all to sit down during the higher ed reform and say, what is this report trying to accomplish, and what is it trying to prevent, and how can we harmonize them and do them together? So that's important to do. But, Ms. Caduto, you talked in your written testimony, I believe, about some of the requirements that are established by the administration that don't necessarily comply, or it's difficult to work around with non-traditional campuses, non-traditional students. Would you care to elaborate on that and talk about how that's difficult to? We need a system to take care of that, but we want to see how the particular requirements make it difficult to comply.
Higher education would greatly appreciate frameworks rather than it goes to what Dr. Roos said earlier, one size fits all. Let's take for example, the differences in in training or education of different constituencies on various campuses. It could say, let's just take, for example, if it were determined by good research that having students in a chair to receive training on violence prevention is the best method. But you are a commuter campus, you are a community college where your students don't live there. You don't have the opportunities to reach them outside the classroom as you do on a residential campus. If you're an online school, and there was an online school represented in negotiated rulemaking, and her perspective kept popping up, and I have to admit, I was like, oh, I hadn't thought about that. We need standards for reaching them with, rather than other than bright line tests. Even the question of what is a student. If a student is taking one class, as an adult learner is taking one class, is that part of the cohort that raises the risk of sexual violence on your campus? Or is it the 18 to 22-year-olds who live in residence? These are all complexities about the differences in who we are as institutions and how we most effectively reach those who need the information. If we're going to engage in cultural change and cultural shift, we have to have the flexibility on the various campuses across this country to reach those different audiences in different ways.
And Dr. Rue, I was going to ask you to elaborate more on your prevention, because that's where we want this. We want to get to zero. We know we have to have systems because we're not at zero. But elaborate on your preventions that you mentioned earlier, and then the ones that you think are most effective to students.
Right. I'm going to turn to some work done by the Centers for Disease Control on this, and they have 9 principles of effective sexual misconduct prevention programs. The first is that it's comprehensive. It's multiple methods, not a one-shot deal, with varied teaching strategies. We know that people learn differently. Some learn through active engagement. Others learn more theoretically. Others more visually. Sufficient dosage. Opportunity over time to deal with these issues. Theory-driven, they have a foundation in theory, that they foster positive relationships. They're not focused on what not to do, but instead what to do. That they're timed developmentally appropriately. If you're just getting ready to graduate versus if you're just arriving, those developmental needs are different. That they're socially, culturally relevant, as Representative Adams has suggested. That we understand the different backgrounds that students bring to us, and that there's an outcome evaluation as well as well-trained staff. So that's what the CDC has. We strive for all of those. I will say that without getting into the curriculum, it is difficult to deliver over long periods of time. We are usually working within a voluntary workshop format for students in our prevention programs. So I would say curricular innovations in this area would be very welcome.
Thanks, and I'll just conclude with the day that you drop them off and you drive off campus, like I said, you're crushed because they're leaving home, but you leave them off and you're also excited for them, and you want them to have that experience of a lifetime, and you want it to be safe and secure. So thank you so much for that, and I yield back.
Thank you, Mr. Guthrie. Ms. Davis, you're recognized for 5 minutes.
Thank you, Madam Chair, and thank you all for being here today. I appreciate that. You know, we dealt with a lot of campus issues around sexual violence, and I understand that campuses have been dealing with them for many years, but in terms of the visibility and the issue, it followed to a certain extent looking at sexual assault in the military. And we introduced a number of bills to try and get at this issue. Not so easy, and I have a few colleagues here from the Armed Services Committee that know and understand that. One of the things that we've been talking about here, which was really critical, was the support for victims, men and women, to have access to, you mentioned a trauma-informed, but a highly professional individual who really can help victims navigate the system and provide the kind of options available to them that they have, whether it's reporting or non-reporting, and what that means actually for them. So I was just wondering, in terms of what you've seen in the campus, the Safe Campus Act or other acts, are there some that you think actually would make it difficult for a student who chooses not to report to have those services, to receive those services? Are there bills that actually do tie the opportunity for victims to be informed by someone who really is highly trained in this area? And quite frankly, I'm not sure that we're there yet in terms of the highly trained, but at least we know where we have to go with it. Anybody want to respond? Do you see that? Are we?
If I can respond real quickly, Congresswoman, the Safe Campus Act has its mandatory reporting provision that would limit a campus's response if a student doesn't choose to report. And FIRE has urged Congress to amend that provision to leave all of the non-punitive measures still on the tables, the ones that you identified that shouldn't hinge on that student's decision. But we do think it's generally a good idea to have campuses make sure that police are investigating. So we think it is a good idea to limit the punitive responses that a school can make.
I'm going to respectfully disagree.
Dr. Rowe,
Yeah.
Ruth.
We know that, that ability to navigate to that confidential victim support person is the most critical thing. And if universities are mandated to report criminally, we know it's going to have a chilling effect on people even getting to the very first resource to help. The truth is most students do not want to go through a law enforcement interview. Our experience teaches us that cops look for violence, for signs of struggle, for weapons. They don't understand the nuance of campus sexual assault. They tend to minimize. If you've read the book Missoula, it provides a beautiful picture of what happens when individuals report in that setting, the kinds of questions they're asked, the kind of doubt that is cast upon them. And again, it has a chilling effect, and it causes many to shut down. So I can't support it.
And Ms. Motz, and addressing as well the harmonizing issue that we mentioned earlier in terms of how universities, how institutions deal with this.
Well, I think the mandatory reporting absolutely has a chilling effect. I think if you're looking for a way to not have students report, not only just to the school, but also to law enforcement, make it mandatory. Part of what we're trying to do with Title IX and the Clery Act is create an environment on campus that supports reporting. If it's going to be supportive to students, it needs to actually be helpful to them. And that kind of reporting not only helps that individual student, but sets the tone on campus in terms of creating a safe
I think what's important about that as well, and the SOS Act that I've authored along with Senator Boxer basically has, I think, actually brought about a number of special advocates on campuses, and 30 in the University of California system, and others, and I think you've mentioned many schools have them. I think the real key is the level of training that they have. But more than that, I think what we've seen in the military system as well is the fact that people generally become more knowledgeable about this process, which has been a very well-kept secret in the past, and I think has contributed to the fact that it's a fearful system, and that's what we're trying to get away from.
And thanks to your work on the military, our ROTC programs are among our best partners now. They are part of our sexual misconduct working group, helping in lockstep with their training resources, and it's a great partnership.
Thank you. Thank you, Madam Chair.
Thank you very much, Ms. Davis. Dr. Heck, you're recognized for 5 minutes.
Thank you, Madam Chair. Thank you all for being here and discussing this critically important topic. Like my colleague, the gentlelady from California, I too was struck by what I thought was a lot of similarities between what you're experiencing on campuses and what we're experiencing within the military, which in and of itself is experiencing an epidemic of military sexual assault. And both Dr. Rue and Ms. Scaduto, in your comments, you talked about things that are very similar, not straightforward or easy to resolve, do not involve force or attacks by strangers, but between individuals who are acquainted. Questions about effective consent, word-on-word conflicts may not be reported for days, weeks, months, and where the survivor has the right to choose a path within the wake of an incident, some reporting on campus or some to law enforcement, similar to the military restricted and unrestricted reports, where in a restricted report it's not referred to law enforcement but allows the victim to partake of the supportive services necessary to help them heal. Question I have is one amongst anybody, has there been any review of what perhaps might be best practices developed within the military, realizing that we are not fully there yet either, but any best practices that might have been implemented in the military's response to this epidemic of sexual assault that may have application into what's being done on campuses?
I'd have to say, I need to learn more about what they've done, and I'm eager to do so. Thank you for that referral.
I think, Dr. Heck, one of the things that I would say is that we've seen an increase in the reporting in the military. And part of the reason for that is because the conversation is being had, because there is now a top-down as well as a bottom-up kind of conversation being had. And there's training going on, and that makes all the difference in the world. The prevention is key, and I think those are all good lessons that we can use for campus sexual assault.
Thank you.
I don't know enough about the military practice to weigh in on there, but what I can say is that one interesting parallel is that last year we heard a lot of chatter about how the military tribunals should not be adjudicating these matters because of the potential for bias there, and that instead it should be removed to civil courts. So essentially the same argument I've been making to you today, which is that campuses maybe shouldn't be adjudicating the facts because of the potential for bias and conflicts of interest instead, and that we should be relying on professionals in courts.
Okay, thank you. A question for my own edification. So if a victim on a campus chooses not to report to law enforcement but comes to the campus authorities to receive the supportive services, does that automatically then result in that case going forward for a disciplinary hearing on a college campus?
No, it does not. It's a very insightful question. The best guidance we get on dealing effectively with survivors of sexual assault tells us that they need the control to decide how to go, if they want to go forward, when they want to go forward, and how they want to go forward. Although the guidance is inconsistent, we get guidance from both from OCR and under the VAWA regs about making that mandate that we give them their options and tell them. And it's funny, as I've listened to the conversation from Congresswoman Davis and others about the use of report, it's banging around in my head because we use report very specifically on campuses. And a report means someone coming forward and telling someone. That's a report, and that's it at its essence. And if they do that, then we wrap our arms around them as a community and make sure that they get the resources they want, they know their options, and if they want confidential reporting, we can direct them in that. But if they come to us and they tell us, that report does not move forward under most circumstances, whether it's internally through our conduct processes or externally through law enforcement or both, without their consent and participation. There are exceptions, as you can expect. I mean, you're lawmakers, you know there are exceptions. If we have an ongoing threat to our community, we might have to move forward without the consent of the person who brought the report forward. And that is also is an example of why safe harbors are important. If we are being guided by the wishes of the victim, but we have an ongoing threat on our campus, and we make that decision to move forward, being protected from action by administrative agencies would be helpful.
Great. So as a father of three, a daughter who's a graduate of college, a daughter who's a junior, and a son who just started his freshman year, I thank you all for what you're doing to trying to make our campuses a safer place. Thank you, Madam Chair. Yield back.
Thank you. Thank you, Dr. Heck. Mr. DeSaulnier, you're next.
Thank you, Madam Chair, and I do want to say, consistent with some of my colleagues, first of all, thank you for having the hearing. I think the hearing helps to draw attention to what's I feel is a real urgency, and I think everyone else does. I hear a great commonality in terms of our desire to take effective action, and we're struggling with what that is. And also, as a parent who's dropped 2 kids off at college, the rite of passage that all of us have shared and the conveyance of that trust that we put in the institutions that we leave them at, and the expectation that these wonderful institutions will not just educate them well, but provide a culture where they feel safe, and that they aren't put in the situation of either being a victim or a bystander. So my analogy, and I appreciate the last 2 comments about the analogy to the military, a lot of this conversation reminds me of the early 90s when I was in local government and the Clinton administration was bringing up domestic violence. And a lot of the conversations we've had remind me very specifically of the challenges, and even though everybody wanted to stop it, we've got to be careful of our approaches because we are all subject to subjective opinions about the relationships between men and women. So to Ms. Mates or maybe Dr. Rue or anyone else, CDC, when they look at the history of, for instance, domestic violence, and no analogy is perfect, I understand but we know a lot now from the 20 years since 1994 when the federal government took a leadership role and passed the Violence Against Women's Act that was just recently reauthorized. So not dissimilar, certainly. And I remember talking to mandated reporters then, particularly educators in high school who struggled with many of the same issues that you do, although because they were in the community, I think they didn't have some of the, maybe the cultural or professional not insular, that's a poor choice of words. Maybe you understand what I'm getting at.
Yeah,
The uniqueness of academia at a college campus.
Right. Congressman, I share your sense of a flashback in many respects. When I was the executive director of Turning Point, which is a domestic violence shelter and program in Ohio, it was during the O.J. Simpson trial. It was during the first efforts to pass the Violence Against Women Act. And so it felt like there was kind of a national teach-in on domestic violence, and people were talking about it. And I see that bright spotlight today on campus sexual assault. I think many of the same things are happening. It's being very much driven by survivors and advocates who feel the time has come. And I think that that also is very similar. I think we can take some lessons from that. We have a lot more data. After 20 years of the Violence Against Women Act, we have a lot more data about how violence occurs. We have police, law enforcement that are a lot more have a lot more data and a lot more experience in dealing with it, prosecutors as well. But I also would continue to stress that when we're talking about campus sexual assault, we want to be mindful of the fact that we're dealing with that as a civil rights issue, and that we need to be really concerned about the access to an education that does not contain sex discrimination. We know too often that survivors will have problems. Oftentimes they'll drop out. That obviously is an interference with their education. Some of them, because of some of the post-traumatic stress and other issues that they've had, their grades go down, and then they lose their scholarships, and then they're the ones who aren't on campus. So it is something that we need to be mindful of. There is the criminal element that we need to talk about and need to harmonize, but at the same time, they are separate and distinct and equally necessary paths.
Well, and I appreciate that, and I'll let Dr. Rue respond as well because you were relating to my initial comments. But we know from domestic violence, and we know, as your comments said, of the causality and the multi-generational aspects of this. So the sooner we get the regulations right, the better, and I would opine, based on that history and others, that the federal government does have an appropriate role in it. Making sure that role is effective, I think, is what we're all talking about. Doctor?
I appreciate the earlier representative who brought up the issue of earlier education. We sadly know through our incoming student surveys that students have already been in abusive relationships. They've already had relationships that were controlling, that left them with self-doubt and unable to stand up for themselves. So we do support, and we do understand these as multi-generational issues. If students don't have excellent role models to look to, where do we find that? So we would love Department of Education to engage the K-12 system in these conversations as well.
Thank you. Thank you, Madam Chair.
Thank you. Mr. Salmon, you're recognized for 5 minutes.
my first question is there any data out there that we can access that would deal with a victim that has initially chosen not to report to law enforcement, who later regrets that and decides they want to report it to law enforcement and they want the individual prosecuted? Is there any data on that?
Congressman Salmon, interestingly enough, there is an absence of that data. We don't know when a prosecutor chooses not to bring a case forward, why they made that decision all the time. Sometimes it could be because of outdated modes of thinking about women and stereotypes, but other times it could be because of spoliation of evidence. We simply don't track that, and that's a major concern, and that's one of the reasons why we think it's so important to get the right medical and
and I guess that's one of my big concerns. I was talking to Dr. Rowe, who's dealt with a lot of victims and had to examine them and deal with them in court proceedings, and a lot of times later on, an individual who decides they don't want that person prosecuted decides they do, and maybe and I have these concerns about going to the university or the college and maybe the counselor or advisor leaning on them, maybe talking them out of prosecuting because of concern for the alleged perpetrator's career or education. Whatever the case may be, I worry about the fact that an individual who decides initially not to prosecute or not to report to the law enforcement, all the forensics is lost, and then several months later or several years later, they decide, still within the statute of limitations, I want that individual prosecuted, so they're not going to do that to anybody else. And then the forensics is not there because it was never reported to law enforcement, and the people that ended up dealing with it didn't have the capability to even put a case together in the first place.
One other critical aspect of mandatory reporting is that there's no way to build up more trust with police than to work with them. You know, we can't fix a problem. If there's a problem in the criminal justice system, it needs to be tackled directly with the criminal justice system. If we're concerned about the chilling effect of having a police officer pick up the phone and say to them, I heard about your complaint, is there something I can do to help? We will never get beyond the barrier of improving that system. They can only do that through working together with trust, and hopefully you'll get more prosecutions and more convictions, you know, if law enforcement is brought in faster.
Well, it seems to me that the dialogue here today has been much more a focus on helping the victim cope and deal, and that's all incredibly important, and to deal with the aftermath and go forward. But I don't hear a lot of dialogue about justice.
Right,
I don't hear a lot of dialogue about keeping evil perpetrators off the streets so they don't do it to another girl. I mean, I have two girls that have graduated from college too, and I'd be livid if some perpetrator who was sexually abused numerous girls and they all decided not to report, and that kid is still out there seeking to harm other girls, and my girl ends up getting harmed. I'm going to be pretty ticked off that guy is allowed to keep perpetrating these crimes.
Right, and I think one other thing needs to be said here about justice. People keep saying that this isn't a criminal justice issue and that the panel isn't going to send someone to jail. That's only partially true. The dean isn't going to sentence someone to 20 years in jail, that's true. But what is important for you to all hear as well is that the transcripts of the hearings are admissible in criminal trials and have been admitted across the country. A prosecutor can independently decide if they want to click print and use everything that was said against an accused student. There's tremendous Fifth Amendment considerations here, so justice really requires meaningful due process, which I'm so glad is part of the conversation now.
Can I just interject, because that was one of my other questions. Talk a lot about due process, and that's a fundamental right here in the United States for anybody that is accused of crimes. Can you tell me the difference between preponderance of evidence and beyond a reasonable doubt?
Sure.
Because that's very fundamental.
Beyond reasonable doubt, which is almost near certainty. Preponderance of the evidence is 50.01% certainty that something was more likely to have happened than not. The difference between being 50.01% certain and 49.9 is so minimal, it really amounts to just which hunch you believe more. That's not a problem in civil courts, where there are all of the procedural protections that go into play: discovery, lawyers, rules of evidence, subpoena power, all of those things. But when you ask people without those other tools to then just decide who you agree with more, that's where you get an injustice. It's when you decouple preponderance from all of the other protections.
I'm going to have to disagree with that. Quite honestly, preponderance is the standard that precludes giving presumption for or against either party. It is the most equitable. Any other standard has already tipped the scale on who to believe.
It's not only the most equitable, it's also the standard that most schools have been using throughout the years, so that it's not new or different. The other part of the preponderance standard is that it is what is used when we're talking about, for instance, Title VII cases, civil cases that are dealing with these kinds of issues, which both have a civil remedy and maybe also could have some criminal implications. So the reality is this is something that schools understand, that they've been using for a long time, and that there's plenty of guidance from the Department of Education as to exactly how they should be using it. Everything is about being equitable, being fair, and being impartial.
Mr. Salmon's time has expired. Mr. Jeffries, you're recognized for 5 minutes.
Well, thank you, Madam Chair. I thank the distinguished ranking member as well for his leadership, and all of the witnesses for your presence here today on such an important topic. I want to start my questioning with Mr. Cohen. So it's my understanding you advocate for weakening the Title IX process in the context of investigating campus sexual assault. Is that accurate?
No, I mean, I wouldn't characterize it as weakening Title IX at all. There are so many things that schools should be doing morally and legally under Title IX to make sure that campuses are safe places. Fact-finding just is not really one of the things they're equipped to do well.
Okay, so but the Title IX process provides for campus adjudications, but you contend that those adjudications are ill-equipped and therefore that should be abandoned. Is that a fair characterization of your position?
I think that would be a fair characterization. There's a long track record of the injustices against both accused and complainants when amateurs are handling these matters.
And you have a greater degree of confidence in law enforcement and the criminal justice system to handle these issues. Is that true? So
there's no doubt that the criminal justice system is imperfect, but that's a persuasive argument for trying to fix and improve that. I have greater confidence in that system because it provides real tools and the actual structures that make sure that everyone's rights are taken into account. And that's so important because I want them to get it right. I want to make sure that if there's a rapist on campus, there's actual consequences that take them off the streets and protect people.
Right, but you acknowledge, of course, that the criminal justice system is imperfect, correct?
Absolutely.
And, you know, there are examples in the criminal justice system of people who've been sentenced to the death penalty who've subsequently been found to have been innocent, true?
There's no system that is perfect, but the criminal justice system is dramatically better at doing this than campuses, again, because of the tools that they bring to bear.
Now, the reason
the
criminal
one
justice
that's
system,
awful and one that might not be very good.
The reason the criminal justice system is imperfect, would you agree, is because of just the context of human error. And whenever you've got humans involved, in the absence perhaps of adequate training, sensitivity, preparation, mistakes will be made.
Absolutely, but that's why we have so many procedural tools in the criminal justice system to try to balance that out so individuals biased can't control that entire process. That's why we have meaningful appeals afterwards in the criminal justice system to provide additional levels of protection for error that don't really exist in campuses, where the appeal often goes to the same person that decided the case, which is why the Safe Campus Act includes that provision about no commingling of responsibilities.
Ms. Matz, could you comment on whether you think there are meaningful protections and/or safeguards in the campus process as it relates to sexual assault outside of the availability of the criminal justice system?
There absolutely are meaningful protections. That's the whole point of Title IX. That's the whole point of the Clery Act, is to have colleges and universities examine those situations when they occur and to respond to them. And respectfully, I would say, with Mr. Salmon's bill, if you make reporting mandatory to the police, you have weakened Title IX. End of story. That's, that you have already said that it's not going to be a parallel process, that it's not going to be an equal process in terms of the emphasis. So that is a bill, I think, that would weaken Title IX at a time, quite frankly, when we need it to be strong, and we need as much technical assistance as we can get from the Department of Education so schools can be the good actors they want to be. The reality is, within the system, they're supposed to have prevention training ongoing. They're supposed to be doing bystander intervention training ongoing. They are supposed to be training the folks who will be hearing these kinds of issues. And they have a choice as to what kind of format they'll use in terms of administration hearing or student code of conduct. There's flexibility here so that they can match it to their school, match it to the circumstances, match it to their community, so that they can get a just result. It is supposed to be impartial and fair, and I do believe that it is.
Thank you. I would just note in closing, as my time is about to expire, that it does seem to me that to the extent that there are imperfections in the context of the campus adjudication process, that we should mend it, not end it, and address issues perhaps endemic to the fact that human error exists in all contexts, just like human error exists in the criminal justice context. But we shouldn't abandon the entire process, particularly given there's a long history in American jurisprudence of having a parallel process. The criminal adjudication process, the opportunity for people to pursue vindication through the civil adjudication process, which, as all of you have pointed out, uses a preponderance of the evidence standard, the same exact standard used in the campus adjudication process. Thank you for your testimony. I'll yield back.
Thank you very much. Mr. Allen, you're recognized for 5 minutes.
Thank you, Madam Chair, and thank you all for coming in, sharing. Back when, of course, my kids say I'm old-fashioned. Back in my day, we didn't talk about things like this. Other than, I will tell you this, growing up, if I ever did anything to harm a woman, I had to answer to my father. And it was, even my little sister, she could hit me and I couldn't hit her back. And that's the way I was taught. I have 3 grown daughters, and of course, full disclosure, I have a son, and he attended Wake Forest University, and we were on the Parents' Council there. And I will tell you this, they showed a film there to the Parents' Council that they show every freshman at Wake Forest College about the problems with alcohol. That was the scariest thing I've ever seen in my life. And I tell you, any freshman that saw that obviously was prepared to know the consequences, at least, of misbehavior. Having 3 grown daughters, you know, I understand. I mean, when your kids go off to college, I mean, you just pray they'll live through the experience, you know, because it's just, you know, I mean, they're free to do things that, and of course, I went to college, so I remember things I did I shouldn't have done. But anyway, let me just say this, that would it be appropriate, like I said, I knew the consequences of my actions. Could colleges and universities, and I know it's very difficult to get in Wake Forest, for example. I mean, my son thought it a great honor to attend that university. But, I mean, can you read the riot act to these young men and just say, you know, these are things that if you do, you won't be here next semester. Mm-hmm. Dr. Rue, would you, I mean, is that, I mean, it looks like to me that this is a university, the universities should set the pace on this and say, there's just some things we're not going to put up with here at Wake Forest. Can you comment on that?
I'd be happy to. I'm going to go back to what CDC recommends in terms of multiple methods. We know that the parental voice is one that students tend to tune out at this time of their lives as they struggle for independence and to find themselves. What we would say is that, and research shows, that if you approach men as brothers and boyfriends of people who might be assaulted, what you get is their empathy. Mm-hmm. And that empathy is a much more powerful motivator than fear of some consequences. And you know, 18-year-olds think they're immortal. So
right.
We really...
Bulletproofs is what we call it.
Yeah, there you go. We believe that engaging men in the prevention effort as coaches, as peers, is way more powerful than figure wagging them. and mobilizing their maturity and their ability to care for their dear friends who've been assaulted. So treating them as potential allies rather than as potential perpetrators is way more powerful.
So I was not, when my daughters would date young men, I would have them in, I'd put the fear of God into them. That was the wrong idea.
With you, sir, I think it might work.
Well, obviously, you know, we were very fortunate, but I have 8 grandchildren and 3 on the way, and 6 of them are little girls, and I've got a 14-year-old, and of course she's entering high school now. So I've had my little talk with her, and but you know, it seems to me that in so many cases that young men just don't know exactly right from wrong. I mean, they've been raised in an environment where they just don't have a value system, and then they commit a horrible thing, and it's like, what have I done here? They really don't know until the consequences are forced on them. So I would please just let, you know, your freshman class know. I know that alcohol, you know, they showed us a film in high school, the State Patrol did, about driving, you know, and of course we didn't have texting back then or phones back then, but basically not paying attention and the consequences of that. And, you know, that stuff, it does register. And at least, you know, someone will know, well, gosh, I didn't know there was anything wrong with this. I mean, you know, these are modern times or whatever. So, but anyway, anything else that Ms. Metz or Mr. Coyne, you'd like to comment on how we gotta stop it.
Yeah.
How do we stop this?
Well, and I think you've hit on a key point in terms of getting men involved. And the reality is when you're doing this kind of programming, men as allies, not accusing, pointing fingers. We know that this happens. Here's what you can do about it, because you have sisters, because you may have daughters, because you have friends that this could impact. That bystander intervention in particular can be particularly effective with men, because they can distract, they can have another conversation, and that peer pressure, you know, never underestimate the power of the peer pressure. Right now, in some respects, it's working against us in terms of campus sexual assault, in terms of the norms, in terms of the stereotypes, and we need to make it work for us. And I think working with men in the process is a great way to do that. The other thing I would say is that you need to bring in other folks from the entire community, not just fraternities and athletics departments, but the entire male community.
Save that comment.
I have one sentence.
Mr. Cohn, I'm going to have to ask you to put it in writing. Thank you very much.
Not a problem.
Mr. Polis, you're recognized.
Thank you. Mr. Cohn, is the problem that you have with the campus judicial processes, is it the standard, or is it what you consider to be a flawed implementation of the standards they use, or both?
I think both.
So now, I mean, it certainly seems reasonable that a school, for its own purposes, might want to use a preponderance of evidence standard, or even a lower standard, perhaps a likelihood standard. I mean, we're talking about a private institution, and if I was running one, I might say, well, you know, even if there's a 20 or 30% chance that it happened, I wouldn't want to. Would want to remove this individual. Why shouldn't a private institution, in the interest of promoting a safe environment, use an even lower standard than a preponderance of evidence, like a reasonable likelihood standard?
Right. Private institutions operate under different rules than the public ones because the Constitution doesn't necessarily apply. So that question has been answered in the public institutions, and that due process is paramount, and due process requires reasonable determinations, which you don't get under the even lower standards than preponderance. Prior to the Department of Education
So is the lowest standard you can use under due process is preponderance of evidence?
The lowest standard you can use in a court for the fact-finding portion would be preponderance.
Well, but I think we're talking about,
But
again, now, so if you're saying it would be a public university, can they say we want to use a reasonable likelihood standard for purposes of expulsion or whether a student can
I don't think that would have any chance of satisfying a due process challenge, but I also
But
would
a
say
preponderance of evidence would,
no. I mean, a preponderance of the evidence can, in some circumstances, pass it and could fail in others, depending on what other procedural protections it's coupled with.
Okay.
When a preponderance of the
it
evidence...
seems like we ought to provide more of a legal framework then that allows a reasonable likelihood standard or a preponderance of evidence standard. I mean, if there's 10 people that have been accused and, you know, under a reasonable likelihood standard, maybe 1 or 2 did it, seems better to get rid of all 10 people. We're not talking about depriving them of life or liberty. We're talking about their transfer to another university for crying out loud, or they go do something else.
Let's be
I
clear
mean,
about
you
this.
know.
That is not
So
what we're talking about.
it's, let me move on. I have a question for Ms. Mance. I want to thank you for your willingness to be here today, and I want to address specific concerns with sexual assault within the LGBT community. Polls have shown that 46% of bisexual women have been sexually assaulted, and gay men are more than 10 times more likely to experience sexual assault than heterosexual men. 25% of transgender people have been assaulted after age 13. What steps can schools take to ensure that sexual assault response teams and outreach is done in a culturally competent way regarding potential victims of sexual assault, including those who are sometimes marginalized and who identify as LGBT?
Right. Those statistics obviously are horrible, and they're more likely to be sexually harassed as well. So the whole continuum of violence is something obviously that we know LGBTQ people experience at a much higher rate. The great thing about Title IX, the beauty of it, is that it's a gender-neutral law. And so right from the get-go, we have a tool that we can use for students to file a grievance if they'd like, to seek assistance. We've talked about having these advisors that can be helpful to students and telling them what their rights are, telling them what the process will be, helping them understand and talk about whether they want to file official charges or not. And all of that needs to be culturally competent and understand that sexual assault is not just a heterosexual phenomenon. It is something obviously.
And along those lines, I think earlier where we were talking about engaging the men, I want to talk a minute about male victims as well. What additional steps or outreach needs to be done with regard to reporting from male victims for whom there can be a whole other set of issues, whether it's heterosexual or homosexual assault or abuse?
Well, I think there's a variety of things that can happen, but I do think in this instance, technology is our friend. Making sure that information that is culturally competent on these issues is available to students, that is sent out to them regularly, that's on the website, that is available in the Student Code of Conduct, that's in the health center, that's in places where gay students socialize and congregate. Making sure all of that is available is huge.
And is it important to show that that potential victims of sexual assault can be of all genders and all sexual orientations as well?
Absolutely. And so when you're training the folks who are going to be dealing with these cases, that has to be a huge element of it. It needs to be something that everyone understands. And quite frankly, there's wonderful guidance from the Department of Education about how Title IX applies, specifically not only in terms of campus sexual assault, but also harassment based on gender identity as well.
Thank you. I yield back.
Thank you, Mr. Polis. Mr. Messer, you're recognized for 5 minutes.
Thank you, Madam Chair. Thank you for holding this very important hearing. Thank you to the witnesses for being here as well. I'm the father of a 12 and 11-year-old daughters and an 8-year-old son, and so they're not quite to college yet, but certainly an issue that means a lot to me. And we have several different college campuses in my district as well. You know, to reiterate what many of my colleagues have said, when parents send their children off to college, they deserve to know that they should be safe. And frankly, if even one student doesn't feel that way or isn't that way, that's one too many. I wanted to give Mr. Cohn just a quick chance to respond to the comments. Just let me ask this question this way. And so given your testimony, what can colleges and universities do to improve their disciplinary processes in an effort to be more fair?
Right. I mean, our plan A would obviously have them not be doing that. But in our plan B, where tomorrow campuses will still be adjudicating these cases, it's important to include real meaningful protections, like a right to counsel and active assistance of counsel for both parties. By the time a school is trying to expel a student, they're not in the category of schools that's trying to sweep it under the rug. But they might not make the case particularly well. So having a lawyer who can speak up for the victim is also helpful to them to make sure the questions they want asked gets asked. So that's number one. The no commingling rule, so the same person who does the investigation isn't also serving as judge, jury, and fact finder. Making sure that you actually have the right to question your accuser is important, because we know that the ability to be put to a confrontation type of clause is what helps us find truth. So there are ways that we can make it better. But I do want to be clear about one last thing. We are not talking about just expelling someone so they go to another school. That is not what's going on. Because when students get expelled, it tracks them for the remainder of their life. Forget about getting a job with security clearance here in this town. Not too many schools are lining up to admit people who've been expelled for sexual assaults elsewhere. And again, the statements are admissible against them in criminal court. You're having 18-year-olds talk on the record about felonies that can put them in jail in Virginia, or Missouri for the remainder of their lives.
Well, reclaiming my time, I mean, I think we all recognize that this is a serious, important crime, needs to be dealt with in a way that practically works. And so kind of opening up to the broader panel, I wanted to talk just a second and get some counsel. As Congress is working through these issues, of course, we have to work through the intersection between the sort of local law enforcement issues and the campus-based disciplinary processes that are in place to deal with student discipline as well. And I think our legislation needs to recognize and accommodate those differences. So could we get maybe some testimony on how to work through that?
I would be happy to at least pile on, if you will, on the issue. The goals and objectives of our internal discipline processes are different than those of the criminal justice system. And I think what's been lost over the last 4.5 years in the efforts of government and other interested parties to make sure that there's accountability for sexual violence on our campuses is the waters are muddied right now about what is the purpose of an on-campus disciplinary proceeding. I will not call it a judicial proceeding. We're not going to find someone guilty of a crime. We're going to be looking at conduct in the framework of our campus community and our campus culture. As Congress moves forward, as OCR moves forward, we need to tease out, and I addressed this in my written comments to this subcommittee, we need to tease out what is the purpose that you see for an on-campus discipline process. I can't speak for Dr. Rue, and I'd ask her to answer quickly on her own behalf, but I believe there are very different purposes. And please keep in mind that not every incident of a violation of our sexual misconduct policies is sexual assault.
Yeah. So invite Dr. Rue to also respond.
Yes, certainly. Again, we are trying to determine whether or not we have a safe and effective educational environment and whether our policies have been violated. We are perfectly comfortable with individuals choosing both pathways, choosing a criminal justice pathway and a university pathway. That we have no quarrel. We really believe the student should be able to decide that. But our goal is to make sure we can remediate our own environment if needed through understanding what the risks are, and to making sure we are lowering barriers to individuals reporting right now, because that is our biggest concern. We know that the incidence established by polls and studies is nowhere near the number of reports, and we'd like to close that gap, and we don't believe that approach would do so.
Thank you for your testimony.
Thank you. Gentleman's time has expired. Ms. Bonamici, you're recognized for 5 minutes.
Thank you very much, Chair Fox and Ranking Member Hinojosa. Thank you for having me join your subcommittee today. This is a topic that has been of import in my state of Oregon as well as across the country. We've had a lot of conversations about it. In fact, just last week, I had a great discussion hosted by Portland State University with our Oregon institutions, primarily the Title IX coordinators. There are a lot of common themes that we heard today, not only emphasizing the importance of the issue, but the regulatory overlap and sometimes conflict. I think you'll find a lot of support among this committee for clarifying that, but also the resources needed to address these issues. And I'm glad we've had a lot of conversations this morning about prevention and the importance of educating students about healthy relationships, consent and what that means, healthy sexual encounters. And I'm glad we're talking about that before college, before they get to college. Now, there were some conversations about the Teach Safe Relationships Act. There is a House version, which I'm proud to co-sponsor along with a couple of other members of this committee. I do invite the other committee members and other colleagues to take a look at that and join on, because if we're preventing, that's the best approach. So we know we can take stronger steps, not only in prevention, We want to make sure that survivors of sexual assault have access to resources, services, and privacy on and off campus. And I want to emphasize that we really need to have policies that encourage, not discourage, survivors from reporting and seeking counseling and assistance. Dr. Rue, you discussed the important role of confidential advisors, and that's something that we're seeing in more institutions. Now, earlier this year, I wrote a letter to the Department of Education about an apparent loophole in FERPA. In some circumstances, attorneys for an institution can access students' counseling records without a court order. The Department of Education's recent draft guidance to address this issue is encouraging, and I look forward to working with administration and advocates and colleagues to close that loophole and provide survivors with the support and assurance of privacy. We want them to be safe, and we want them to feel safe. And if they have a sense that their records are not going to be kept confidential, that may discourage them from seeking the support that they need. So my home state is working on this issue. Earlier this year, our Governor, Kate Brown, signed legislation making clear that conversations between alleged campus assault survivors and their advocates are confidential. Oregon also passed a bill that requires schools to give students who report sexual assaults written notification about their rights, legal options, campus services, and the state and community resources. And I just want to give a shout out to Brenda Tracy, a brave survivor of a gang rape on a campus several years ago, who is now a nurse and an advocate. So these policies are important for students, not only in Oregon, but across the country, and I'm really glad we're having these conversations today. And I want to ask you, Ms. Matz, we know that more institutions are starting to educate students about their rights under Title IX. Oregon State University, for example, is going to be opening a survivor advocacy center to provide confidential and accessible services. They're going to have a full-time advocate there. So what can we do to expand services like that so more students know their rights, and what's the best way to let survivors know what resources are available to them on and off campus, and also let all students know that? Not just survivors. They
Right.
need to know what's there, and
Right.
what's the best way to do that.
Well, Title IX absolutely requires schools to not only put together an anti-discrimination policy, but to also have grievance procedures, and most importantly, to publish it in an ongoing way, to publicize it to students, to faculty, to staff. And technology can be our friend there in terms of making sure that it is distributed frequently. It should also be used, obviously, in any on-campus prevention programs and so forth. I'd like to get back truthfully to the climate surveys, because one of the things that I think is overlooked with the tool of the climate surveys is it does give an opportunity for students to talk about their experiences. And in a climate...
Right. And to reclaiming my time, I wanted to get to that issue. So in the few remaining seconds, could you talk about, because there's such a diversity among colleges and universities in size and resources, and we want meaningful responses. So do you have any suggestions about how we can accomplish that in a nationwide climate survey so that we get equity in response and distribution and participation?
Right. Well, we need to actually make sure that there are certain questions that all climate surveys ask. I think that's very important. The HALT Act would do climate surveys, and we need to have that generalizability across the country. At the same time, each campus can personalize that particular climate survey to make sure they're asking questions key for their community, key for their constituents. And what's good about that is that it not only provides information to the school about what they should be doing, what they're doing that students don't like, what they're doing that could be better, but it lets the students know that the university is paying attention, that there are these programs, that there are these rights, that there are these protections. And that in and of itself is a huge community education program, as well as a data finding program that helps to make things better.
Terrific. My time has expired. I yield back. Thank you, Madam Chair.
I understand that Congresswoman Spear would like to speak, and I ask unanimous
consent that she be allowed and permitted to join the committee members for today and participate in this important hearing.
Without objection, Congresswoman Spear is recognized for 5 minutes.
Chair, thank you very much for allowing me to participate today. I apologize for not being here for the entire hearing. Excuse me, I had a funeral to attend. But I want to applaud the committee for recognizing the gravity of this issue and the importance of putting a spotlight on the issue and coming up with some solutions to dealing with it. I'm sure you've undertaken a complete review with the panelists that are are with us today, many of whom are experts, about the fact that this is indeed a very serious problem. Regardless of how you crunch the numbers, the incidence is widespread on college campuses, and we need to take steps to address it. Let me say at the outset that I have worked on this issue now for over 2 years. I've worked very closely with my colleague on the other side of the aisle, Pat Meehan, and we have introduced the HALT Act. But in doing all of this, we've spent time with the Office of Civil Rights, and I want to commend them. The OCR within the Department of Education in the last couple of years has done an outstanding job of creating greater accountability, frankly, because we have seen for a very long period of time that the Title IX coordinators on most college campuses weren't even available to people. They were oftentimes buried in websites. That all is changing now, due in large part to Dear Colleagues letters that have been sent out by OCR and others. It's personal to me because I have a daughter who's in college, and every college that we visited before she chose the college that she is now at, the first question that was asked by every parent, the first question when we were at orientations was, what was the safety of that college for their child? And this is a bipartisan issue, Madam Chair. I can't tell you the number of Republican fathers and Republican mothers who have said to me, I am really upset that this issue hasn't been dealt with appropriately. And frankly, sometimes it's not until you're 6 degrees of separation that you appreciate how close it can come to you. So climate surveys, which we have used very effectively in dealing with sexual assault in the military and has been used in the military for a long period of time, is something that we want to see incorporated by universities. It is a picture that helps them appreciate how significant the issue is. The HALT Act will also provide for a number of other elements. You know, one of the things that Title IX does, it's a heavy hammer. If you aren't providing the kind of non-discrimination in education, you can lose all your federal funding, which means you lose all of the grant money, you lose the option for student loans, and so it is a heavy hammer. But it is, I think, important to create a system that provides some fiscal penalties short of that heavy hammer, and the HALT Act would do that. It would also increase the violations, the penalties for violations to the Clery Act from $35,000 to $100,000 and create a private right of action under Clery for students whose institutions fail to inform them of safety risks and of their rights. It provides more money for investigators in the Office of Civil Rights by about $5 million, and as an effort to decrease the backlog that exists right now with the Title IX complaints that have been filed. Now, I spoke to a number of young women who had been assaulted at the University of California. I won't name the campus so they won't be drawn that closely under the microscope. But in talking to these young women, and there's nothing like hearing the stories of these youngsters to appreciate how insidious this can be. And in any of those cases, the victims were never even interviewed. That's maybe shocking to some of you, but that was commonplace. And how can you properly evaluate a case unless you interview both the perpetrator or alleged perpetrator and the victim as well? The question as to whether or not colleges should be engaged in this at all, and Ms. Scaduto, you had referenced that a few moments ago, you know, is probably a legitimate question. You all have codes of conduct, though. And under that code of conduct, if you violate that code of conduct, you take actions to remove those individuals from the campus. So you certainly have the wherewithal, and you certainly use that code of conduct in dismissing or suspending students who don't comply with the rules of the university. And I would suggest by being engaged in something that is clearly a crime, which rape is, that meets the standard of suspending or terminating a student. But I also appreciate that you have to weigh the various interests. I do think that the Office of Civil Rights needs more resources. I do think that we should create a proactive responsibility that institutions, plaster the notices of how you can seek Title IX coordinators in the bathrooms of every dorm and sorority and fraternity, and those simple things. The whole that goes beyond that, and I see my time has expired, and I thank again the chair for the opportunity to participate.
Thank you very much. I want to thank our witnesses again for taking time to be here today. I would like to recognize the ranking member for any closing comments.
Madam Chair, before I give my closing statement, I ask unanimous consent that the following 5 documents be submitted into the hearing record. Number 1, the U.S. Department of Education's 2014 Guidance on Title IX and Sexual Violence. Number 2, U.S. Department of Education's list of higher education institutions with open Title IX sexual violation investigations as of September 2nd, 2015. Number 3, U.S. Department of Education's table chart, Title IX, Clery Act, FERPA. Number 4, the letter from the National Alliance to End Sexual Violence. And lastly, number 5, the letter from Feminist Majority Foundation. I ask unanimous consent that that be done.
Without objection.
Thank you. For my closing statement, I'd like to thank all of our witnesses for spending their time with us at this important hearing this morning. A combination of publicity and heightened scrutiny is leading colleges across the entire nation to place more emphasis than ever on preventing and responding to sexual assault on their campuses. Sometimes victims of these horrendous crimes do not know who or where to turn because they believe no one will understand them, or they believe that reporting a crime could bring them much more harm. This is why it's imperative that institutions of higher education which deal directly with our students have the resources to provide the victims of sexual assault and the accused with help and comfort so that they and those affected by that crime will fully recover and not miss out on their educational opportunity. And with that, I yield back.
Thank you, Mr. Hinojosa. Again, I want to thank our witnesses. I want to thank everyone who came here today. I especially want to thank our staff for the excellent work done on putting this hearing together. And in the interest of time, at the beginning, I did not acknowledge that Dr. Rue is from Wake Forest, which is in my district, and I'm very grateful to her and for that wonderful, wonderful institution that is there. I want to say that I deplore violence of any kind. I don't even watch any kind of movies with violence in them because I cannot abide violence. And this is a very important issue. It's important to all of us. Again, I have a grandson who went off to college this fall for the first time. So those of us in particular, again, who have children at colleges and universities, but every American, everybody on a college campus deserves to have a safe environment to learn. We want that for all of our students. And so I believe that today's hearing has brought forth some important information that will inform us as we go forward in the reauthorization of the Higher Education Act. And I appreciate, again, the witnesses, my colleagues who came and asked very thoughtful questions, and everyone who's here to learn more about this issue. There being no further business, the subcommittee stands adjourned.
Thank you.
Thank you.
Nicely done. Nicely done.
One thing I wanted to stop and make everyone to consider today, because I'm concerned about the confidential advisor, not because I think it's a great idea, but my concern is that they're actually confidential. Under federal and state law, if they're not actual therapists, or they don't fall under anything privilege, it's all
Yes.
Not actually sure the moment the prosecutor says it's sexual. So I want them to get those confidential resources because I actually think it's a great idea, but I'm very concerned about the mechanism that we're using to create it. I don't think it actually.
Well, it's a state-by-state pastiche of who has legal confidentiality. This is a real easy way to do it.
Every federal court too also.
Yeah, understood. We did. I got the last. Wow, wow, didn't it?